All right, folks. We're actually going to start on time this evening. We're only 2 minutes late, I should say. So we're gonna go back in session on the Mountain Trail Solar conditional use. At the end of the last hearing, I had told parties and council that I would be sending an email with regard to exhibits that were admitted. I did get a response from Mr. Gallagher, and in his response, he indicated that he had applicants exhibits 1 through 56 as admitted, correct, Mr. Gallagher?
Yes. Well, aside from the 50, was it 50, which was the economic impact study, and 52, which was the revised glare report.
Okay.
And then 58.
Well, that's after 56.
Right, correct.
So my indications are that would agree that those exhibits would be admitted, so that would be 1 through 56, other than, say those numbers again.
50 and 52.
Other than 50 and 52. Mr. Cluck, do you have a different recollection?
Hold on.
For those in the audience, this is the watching paint dry section of the proceedings.
$57.
Again, after 56. We're only doing 1 to 56.
Oh. What was 12 and 13?
Great Valley. 12 was the first.
No problem. I'm okay with 12 and 13. $19. That's the PNDI. I'm okay with that. 20, okay. That's a large skip you have between 18 and 32.
What are you referencing?
Your list.
Well, based on what I'm saying is 1 to 56, I believe, with the exception of those two that Mr. Gallagher had mentioned, were already admitted.
I don't have a problem with it, except they weren't admitted until tonight.
No, I think that they were admitted. It was just how Jen was referencing them in the transcript.
Okay. No, there's nothing. Okay. But 52 is a no, right? Okay.
Then I believe 57 was admitted. It was.
One moment, Mr. Gallagher.
Sorry.
Mrs. Palahnuk, do you have any input on this?
0.
Mr. Hartman? Not here this evening. Mr. Hoffner? Mrs. Stabile?
Here.
Here. No one's sitting in their assigned seat, so that makes this very challenging. Mr. and Mrs. Yaub? So not here. Mr. Elsenbach, I see you in the back.
No, I'm good.
Mr. Balthaser?
No.
Mrs. Balthaser? Ms. Fowler?
No objections.
Mr. Fowler?
No.
Okay, so let's move on to applicant's exhibit 57. That was the list of projects that Mr. Hughes brought with him to the hearing.
Yeah, I thought that was admitted, and he testified to it at the last hearing, substantive hearing that we had.
That's my recollection as well. Mr. Cluck, do you have a different recollection?
That's his exhibit. I guess he testified to it, and we had an opportunity to cross, but not an opportunity to verify what's in the exhibit. I'm not going to object to his admission.
Okay. Mrs. Palahnuk, any objection? Mr. Hart, here. Mr. Ossenbach? Mr. Balthaser?
No.
Mrs. Balthaser?
Yeah.
Ms. Fowler?
I believe I admitted that exhibit at the last hearing. It wasn't in the record previously.
The list of projects for Mr. Hughes?
Yes.
Do you object to it?
I don't object. I'm just saying I'm the one that introduced it into the record.
Thank you. Mr. Fowler?
No objection.
Okay. Exhibit 58, from what Mr. Gallagher indicated, that was Michael Sveen's memorandum, which was previously marked as Exhibit 48.
Correct.
But it's actually Exhibit 58.
So I think it was just an error. I had pre-marked that is Exhibit 48 and thought Mr. Sveen would be testifying in March, but for whatever reason, how things played out, he was our last one. So I handed out the exhibits, and we happened to be on, I think, Exhibit 57 at the time, or 47, and I think it was just maybe heard as 58 instead of 48.
Okay.
My point is that's the exact same thing. 48 and 58 would be the same thing.
Okay, so the record will be noted that Exhibit 48 and Exhibit 58 are the same document. They're both admitted into the record. And then, okay. Okay, I think that covers what was in your email. Mr. Cluck, do you have
Yeah, 16,
applicant 16 or objector 16?
objector 16
Objector 16.
was admitted. It was the Department of Ag guidance document. And according to the transcripts, it was admitted on page 915.
Okay, so Exhibit 16 is already been made part of the record. Just to be clear, we already have as part of the record objectors 5 through 9, 10, 11, 12, 13, 14, 15, now 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, and 28.
1 through 4, Exhibit 1, we marked the narrative. We didn't move to admit it because it's part of the board's exhibits.
Correct.
2, 3, and 4, I believe, are my entries, various entries of appearance, and there's no reason for that to be admitted.
I think they should be part of the record. So
Okay, then 2, 3, and 4 should be part of the record.
So 2, 3, and 4 are admitted and shall be part of the record. Did you have any other exhibits that you believe should be? Okay. Mr. Balthaser, we have for you exhibits 1, 2, 3, and 4, which are part of the record. I don't think you offered anything other than those.
No.
Okay. Ms. Fowler, we have 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10.
Correct.
Okay. And then Mr. Fowler, I have 1, 2, and 3.
Sounds correct.
Okay. All right, so then we have, I think we've cleared up, just so we know exactly what is on the record. And then the next thing we were gonna do this evening is start with our closing arguments. And it's my intention, because the applicant has the burden of proof, to allow them to go last, to have the final word. I know, Mr. Cluck, you may not agree with that decision, but I think that way we don't, there won't be he won't have a chance for a rebuttal. Everyone will get one chance to go. Mr. Cluck, the floor is yours.
Sorry, folks. my back will beat you. Do I get the reserve time for rebuttal?
You may reserve time for rebuttal.
2 minutes. Is this on?
No,
That-
the mic's
that's-
above you.
That's a show mic on the
Yeah.
podium. There are mics on the ceiling.
So I don't need to,
No,
You don't need to worry about that.
Aim with the stand.
But the ceiling mic is right above you, I believe, so the
Okay.
people in Zoom land can hear you.
may it please the board. See, I'm used to may it please the court. I got to say may it please the board. I'm Bill Cluck. You know me well. I'm representing a group of citizens that call themselves, let me get their name right, Windsor Berks Concerned Citizens, and a number of individuals who I will name when we get to them. The original applicant, Mountain Trail Solar LLC, does not and did not have legal standing to submit the application when it was submitted. The attempt to cure their lack of standing at the 11th hour on November 30 by having their parent corporation, Leeward Renewable Energy Development LLC, execute an assignment and assumption is a cure that's not timely and is not supported by court decision or the municipality's code. 2 of the lots are less than 5 acres of the lots where they propose to put the solar farm. That is not in compliance with the minimum lot standards in the zoning ordinance. The promise by the applicant to merge those lots at land development is what's known as a promise to comply. A promise to comply at this stage in the zoning proceeding, according to case law, is not authorized.
Do you have a case cite for that?
I will in my closing, in my proposed, yes, obviously I will. The narrative in the application is supposed to be true and correct and accurate. There are a number of false statements in the narrative, which I will note has never been corrected or revised. The applicant has failed to meet some of the express criteria set forth in the zoning ordinance, and most importantly, the objectors that I represent, as well as the unrepresented parties, have met their burden to show that this project will have an adverse impact on public health, safety, and welfare. To begin, under the municipality's planning code, section 603 authorizes the local government to have provisions for conditional uses based on a public notice and hearing and the recommendations by the planning agency. Who has the burden? The applicant for conditional use, Mountain Trail and Leeward, have the burden to demonstrate compliance with the specific criteria. If and once they meet the requirements, and we do not believe they did, if they've made out what's called the prima facie case, their application must be approved unless my objectors present sufficient evidence, which we believe we have, that the proposed use has a detrimental effect on public health, safety, and welfare. In addition to the citizens group, I represent Jeff and Cindy Bryan. Jeff testified. Carol Burkert, James and Linda Costa, Dean and Debbie Heckman, Breland and Linda Wood, Mike Palahnuk. Pronounced that right, didn't I?
Did
Susan.
Mr. and Mrs. Wood testify? I don't remember.
No, they're just
Okay.
on my list of clients.
Okay.
Mike Palahnuk, Susan DeKirk, Tim and Lois Peters, Ron Stabill, Robin Davis, Julia Davis, Alex Davis. The Davises withdrew their appearance at a later date. There was an amended entry of appearance, first on behalf of Scott and Gwyneth Fowler, and then removing Scott and Gwyneth Fowler as clients, and we added Gloria James onto my list of representatives. What hasn't been discussed in this proceeding is there was a prior decision of the zoning hearing board with respect to a request for variance for an earlier version of this solar project. On March the 3rd of 2022, there was a written decision by the zoning hearing board denying the variance. Two of the findings made by the zoning hearing board, and we will argue, we believe that they apply in this proceeding, that there's res judicata, that there's an identity of parties, even though it's a zoning hearing board, it's still the township. Number 31, the solar facility will alter the essential character of the surrounding neighborhood and the zoning district of the subject property. And number 32, the solar facility will be detrimental to the public welfare as the applicant presented no credible testimony. The solar facility, if developed, would not have a negative effect on neighboring property values. As you know, we've had almost a dozen hearings.
Mr. Cluck, before you move on, how do you address the fact that that decision that you cited from the zoning hearing board is still an appeal pending before the Court of Common Pleas and has not been fully and finally resolved?
I don't believe it's supersedious or stay of the proceeding, therefore the findings are still valid until overturned.
Okay. I hope that if you have case law on that, I expect you'll submit that with your.
Yeah, on res judicata, absolutely.
Just because I think that's an issue, and I'm sure that applicants council will address this as well.
I have no doubt.
But my concern is whether or not that can be considered a final order when it's still subject to an appeal, and how that would affect your res judicata argument.
Okay, understood. Now, relevant case law. This is on the contents of the application that's before the board. In the Edgemont Township case, it says the applicant for either a special exception or conditional use must, and the word must is mandatory, demonstrate the proposed use meets the applicable requirements of the zoning ordinance when the application is submitted. A promise to comply or conditions compelling future compliance cannot cure an otherwise non-compliant application. Edgemont Township. That is cited in Ray Thompson, 896 Atlantic 2nd, 659 at page 680, Pennsylvania Commonwealth, 2006. That's your case.
Can you repeat the site, please?
896 A 2nd, 659 at page 680.
Thank you.
Commonwealth Court. The Township zoning ordinance has a similar provision as the case I just read. It says in 806.1, under conditional uses, the application shall, again, another mandatory word, not a discretionary word, shall be accompanied by the material and data as required by the ordinance. Mountain Trail Solar submitted the application January 4 of 2023. I will note Mountain Trail Solar is not a legal foreign corporation in the Commonwealth of Pennsylvania. They are admitted, they're incorporated in Delaware. They are not qualified to do business in the Commonwealth, and neither is Leeward Renewable Energy Development, LLC. The conditional use application of January the 4th of 2023 had a handful of exhibits, as you know. The original conditional use plans dated January 4. Photographic simulation renderings, Board Exhibit 3. DEP guidance document, Board Exhibit 4. The wetland delineation report, May 24, 2022. The one submitted to the board was the revision number 1 of November 21, 2022. We now have revision number 2, which is not in evidence. We didn't move for it to be in evidence, neither did the applicant, but it was provided to us after Mr. Sveen testified, and one of his list of exhibits of documents he reviewed was this updated wetlands plan. Revision 2 is dated February 6, 2023. That should have been part of the record. That should have been before the board. There should have been testimony about it, but there wasn't. And then finally, there was a cultural resource analysis, November 2022. That was Board Exhibit number 6. The Planning Commission has a role. 806.1 says the governing body, that's you folks, shall submit the application to the planning commission for review. They met on June 20 and they recommended denial. Their letter of denial was dated October 16. It's board exhibit number 6. No other documents were provided to the planning commission after their June 20, 2023 recommendation of denial. There was a handful of letters from Great Valley Consultants, the township engineer, that have applicants exhibits 13, 14, 15, and 16. When I first looked over this, I said, geez, this is not land development. Why are there so many letters going back and forth between the applicant and the engineer for the township? Because that's what happens at land development. That's not what happens at conditional use. A closer look at exhibits 13, 14, and 15, they're basically identical. It's the same set of comments, primarily about section 615, the express criteria in the ordinance. In response, the applicant has revised the conditional use plans a number of occasions. January 4, original. February 27, 2023 was revision number 1. We've never seen those plans. Revision number 2 was dated October 18 of 2023. That's applicant exhibit 16. And then January 9 of 2024, board exhibit 30, which I have objected to that, and the board is supposed to look at those plans with the weight they want to give to it. And then finally, on April 29, revision number 4, which added buffers around certain areas. Here are the list of documents submitted after the original application, which I will argue should not be considered because they aren't in compliance with case law or your own zoning ordinance that required the application to be complete at the time it was submitted. We have Exhibit 11, the decommissioning estimate, September 29, 2023. We have the so-called PNDI searches for the Gaspari and Frederick properties, May 2022, October 2022. These predate the January 4, 2023 application. U.S. Fish and Wildlife reviewed the Phase 2 Bog Turtle Survey, September 15, 2022, Exhibit 21, predates the application. March 1st, U.S. Fish and Wildlife has a review of an updated Phase 2 survey. March 20, 2023, Army Corps of Engineers preliminary jurisdictional determination on wetlands. Exhibit 24, we have a sound study dated December 6, 2022. That was not part of the original application. Why wasn't it part of the original application when it was submitted January 4? This is a December 6 study. October 13, property value impact analysis. October 13, a site-specific analysis of property values. October 18, the 927-page stormwater management report. May 10, 2023, Garen Gafford's solar heat island effect. October 2023, solar glare and glint analysis report. And finally, Tommy Cleveland's health and safety assessment report, October 23, 2023. All of that should have been part of the original application. Instead, we've had hearing after hearing after hearing, back and forth, looking over these documents. It all should have been up front. I've already told you who my clients are. The zoning ordinance in section 103 sets forth the purpose of the zoning ordinance and a statement of community development objectives. The ordinance was prepared with careful consideration given to the following: the character of the various areas in the municipality. And we have had testimony from Mr. Fowler on the character of the neighborhood, as well as my individual clients have testified about the character. The purpose of the ordinance is also to conserve the value of property, and I will get to that in a moment. The zoning ordinance is intended to promote public health, safety, morals, and the general welfare by conserving prime agricultural land, and these properties are prime agricultural land that are not being preserved. It's not a temporary use when you're talking about taking it out of active use for crops for a 40 or 50-year period and hopefully returning it at some later date in another generation. That's not conserving prime agricultural land. Finally, preserving natural, scenic, and historic values in the environment, preserving forests, wetlands, aquifers, and floodplains, and that'll go to the Environmental Rights Amendment, Article 1, Section 27 of the Pennsylvania Constitution, which I will close with when I get to that part of this. The specific purposes for the zoning district involved, the agricultural district, are numerous, and I'm not going to go through all of them at this point. I'll save some time. They'll be in my proposed findings and conclusions as well. Section 615, these are the express standards they have not met. 615B as in boy. Systems shall have a minimum lot size of 5 acres. 615E, no part of a ground-mounted commercial solar energy system or its support structures shall exceed a height of 20 feet. Mr. Hay reported on that. 615N, as in Nancy, solar energy systems shall be located on a building lot or parcel in a manner that avoids directing concentrated solar radiation or glare onto any adjacent property or public way. I think clearly, based on the testimony and cross-examination, there is yellow glare associated with this project, and I suspect some of the non-represented parties are going to get into this issue in much more detail. Section 806.5, these are the general requirements, and there's a recent case that shifted the burden to the applicant. Normally, the cases have said that the objectors have the burden to prove the adverse impact on the general welfare. There's a recent case that's not reported, but it's on the Commonwealth Court site, that shifted that burden to the applicant.
Do you have?
I'm not in front of me, but I'll have the unreported decision. Maybe it'll be reported by the time we submit our findings. 806.5, Toby Fawford testified in length about how the standards, the general requirements were met by the objectors. I'm not going to go through it in detail, his testimony. I highly recommend reading it. Let's talk about property values. Jeff Bryant at 130 Blau Road, they live directly across the street. It was his belief that commercial solar farm will adversely impact his property value. Now that's going to be characterized as pure speculation. He's not an expert. Let's look at what their expert has in his report. Mr. Linus of Cone Resnick prepared 2 large documents, which frankly were boilerplate that I've seen in other cases. Exhibits 29 and 30. Exhibit 29 had an effective date of June 2023. Exhibit 30 has an effective date of November 2022. His conclusion, quote, "I do not believe the proposed project will have a negative impact on surrounding property values," close quote. Not a surprise. But he relied on an academic study from the University of Rhode Island. If you look at the study, Exhibit 29 at pages 22 and 23, he only mentioned his interpretation of certain aspects of that study that purported to support his claim of no damage. Here's what the conclusion of the Rhode Island study actually says. Quote, "Our preferred model suggests that property values in the treatment group declined by 1.7%. on average compared to those in the control group after the construction of a nearby solar installation. All else equal, quote, we find substantially larger negative effects for properties within 0.1 miles and properties surrounding solar sites built on farm and forest land in non-rural areas." That's Windsor Township. The people I represent, the people I don't represent who are parties in this case, are all in close distance of this proposed solar farm. There will be a negative effect on their property values, quoting their own experts' report. We had Dr. Laura Goodrich testify from the Hawk Mountain Sanctuary. Rather than waste a lot of your time, I highly recommend reading her testimony. The bottom line is the migratory bird patterns will be adversely affected by the removal of the 400 acres of agricultural land being replaced with solar panels, which has a risk of harming the migratory effects, and it's not a function of, oh, well, they'll find another place to fly. We're talking about birds and raptors that come from Canada down to Florida, and Windsor Township is a stopping place for them. Read her testimony and her conclusions. Same with Toby Fowler, our certified community planner, who identified the issues associated with the purposes of the agricultural district. Finally, Bruce Hay testified at length regarding height, decommissioning estimate, stormwater, managed release concept, significant mass grading, noise, steep slopes, and glare. With respect to height, he testified at length that none of the projects he's worked with that were 69 kilovolts, I think I have my math right, did not limit height to 20 feet. That he testified it would go beyond the statute, the zoning ordinance provision of 20 feet. On the decommissioning estimate, he said the estimate does not adequately address upon removal the cleaning, restoration, and revegetation to blend with the existing surrounding vegetation. On stormwater, he criticized at length the use of the managed release concept. We understand stormwater is not an express criteria, but that the applicant included stormwater in their application. Therefore, I think they're bound by their application. Their application, their stormwater report does not meet the township's stormwater management ordinance. This site is not eligible for managed release concept because they've done no site investigation on infiltration into the soils on these properties. There is significant mass grading that will occur if this project is approved. The consultant for the applicant claimed it would be insignificant, it would be limited. I think you can tell by your own eyes looking at the plans and the testimony, there's mass grading that will occur. With respect to noise, we were highly critical of their so-called sound study. They don't meet the standards of section 608.5. Steep slopes, they didn't even bother to identify steep slopes between 15 and 25%. DEP will not allow solar panels on steep slopes, no matter how many projects are purported to have DEP's approval. I wish I had more time to investigate more than the two I investigated, and I'm not going to mess up the record telling you my findings. I question Exhibit 57. I question the credibility of Mr. Hughes. As for glare, it's obvious. They have a problem with glare. They needed a second consultant to come in to correct the first glare study. It shows there is yellow glare. It will have an adverse impact on properties and the roadways, and I'm going to allow other members of the community who know much more about glare and did much more work on that for them to testify. Finally, the Environmental Rights Amendment. I don't know how much you know about it, but Pennsylvania Supreme Court says it's self-executing. It applies to local government, not just DEP. And it says local government has a duty as a trustee of our natural and historic resources to protect the public's right to clean air and clean water. Clearly, there are natural and historic resources. They've been identified in the Berks comprehensive plan that we introduced sections of the natural heritage areas. We had the people from Hawk Mountain Sanctuary testify. There is no doubt there's natural and historic resources that we believe will be adversely affected, and it's up to the township to ensure that those adverse effects are mitigated. With that, I ask you to deny the application. We appreciate your time, we appreciate your effort, but this application doesn't bear weight. It should be denied. Thank you.
Thank you, Mr. Cluck. Any members of the board have any questions for Mr. Cluck about his argument? Mrs. Palahnuk.
Well, I'm not near as organized. and I'm only 2 pages. I believe that one does not have to be a tree hugger to recognize the importance of keeping strong balance of open areas. Open areas provide not only agricultural endeavors, but also supports wildlife and community needs. The more this open land shrinks, the more pressure it puts upon remaining cropland. Deer destruction is real. Shrinking their habitat by fencing in such large areas can cause more problems for farmers that actually produce crops on their land. Open land also supports the passive recreational opportunities such as bird watching. This area they want to use is so diverse and important to the migrating flocks of snow geese, tundra swans, and many kinds of raptors, bordering such an important national landmark, Hawk Mountain. This project, as best I can tell, and you can correct me if I'm wrong, this project will take up roughly 8% of the arable land in our township. That's a lot. 3% of the entire township. I think that's a pretty substantial amount of land to give over to such an endeavor. We all have our opinions, we all have our thoughts, we all have our everything, but I think the supervisors need to adhere to the ordinances as most of us understand them. Section 403(1), A, C, E, G, H, I, J, L. I'm not going to word them out because we all know them. We've all been reading them for the last year. You might look at section 402(1), A through E. In response to some questions and challenges put forth by a supervisor, yes, we should be able to use our land as we see fit, unless it negatively affects residents and neighbors. If it negatively affects residents and neighbors, we have the right, I'm going to rephrase that, we have the responsibility, we have the duty to object and maybe request more research. When moving into a new community, if we move into a housing development, we can reasonably assume there will be more neighbors, more houses built, more developments. If moving into an agricultural community, we should be able to make a reasonable assumption that cropland will remain cropland. It makes me uneasy that this company does not seem to feel it necessary to cross their T's and dot their I's and provide all pertinent information in a timely manner. If their application process is such, I would hesitate to entrust a project such as this, a project that affects the township residents and negatively impacts the neighboring landowners. The confusion of exactly who business is being done with. Mountain Trail Solar versus Leeward Energy. There's a lot of stuff in the transcripts, pages 232 through 245, pages 228 and 29, pages 209 and 10, pages 446 through 449, and pages 609 and 610. That's the only examples I was able to locate in transcripts, but it was under a lot of consternation. I would also like to add that the project manager, Mr. Horatio Larios, made it very clear that the continual active ownership is not necessarily a part of their plan. This can be found on transcript pages 1377 through 1378. I think our supervisors need to truly be aware of this. You may not be doing business with them in the future. In closing, we are all here, all of us, because we care about our community. We care about the land, and we recognize that this is not the best path forward for this community. Being a community means we serve the greater good, not just those who will benefit. I really, really hope our supervisors will take what we say to heart and really listen, deny this application, and adhere to our own ordinances. Thank you.
Thank you, Mrs. Fowler. Gentlemen, do you have any questions for him? Okay, Mr. Osenbach.
I'm not prepared.
Mr. Balthaser.
Yes.
This is our new reality. You vote yes. I'm not going to shine this in your eyes, but we're going to be seeing this glare. many hours of the day. The conditional use application for this solar farm is in direct conflict with Section N, Section 615, Solar Energy Systems of Windsor Township Zoning Ordinance N. Solar energy systems shall be located in a parcel or manner that avoids directing glare onto any adjacent property or public way. According to applicant's glare study and my analysis of it, yellow glare sourced from 5 feet from the ground will be cast on 3,900 feet of Blau Road, 2,200 feet of Gruber Road, 1,500 feet of Hess Road, 1,000 feet of Klaus Road, 2,000 feet of Monument Road. Approximately 10,600 feet of roadway will be exposed to yellow glare. That's 2 full miles of yellow glare directed on public ways. The applicant's witness, Mr. Cleveland, testified that a pilot's ability to fly was potentially impaired after more than 5 seconds exposure to glare. Pilots are analyzed similarly to drivers according to page 5 of the applicant's glare analysis. The posted speed limit on the roads analyzed is 35 miles an hour. At that speed, a car travels only 260 feet in 5 seconds. 260 feet until a driver is potentially impaired. Even the roadway with the shortest distance of yellow glare, Klaus Road at 1,000 feet, a driver will be potentially impaired after traveling only a small fraction of the total distance. Driving a vehicle when impaired is dangerous and illegal, according to Pennsylvania driving laws. What's going to happen when a driver attempts to travel the entire 3,900 feet of Blau Road when yellow glare is present? At 35 miles an hour, it will take 76 seconds to travel 3,900 feet. That's 15 times the 5 seconds it takes to become potentially impaired. How will drivers be able to clearly see other vehicles, school children, joggers, or animals? Clearly they will not. Will a driver's impairment from glare end when the road ends? Most likely not. At that point, there's a good chance that we'll be turning onto one of the other roads and endure hundreds or perhaps thousands more feet of yellow glare, potentially further impairing their ability to drive. All the roads I referenced are connected to each other. But aren't these yellow glare periods projected to be just a few minutes a day? No, the yellow glare will last for hours a day on some days. 2 periods of yellow glare per day are predicted according to the applicant's glare study and my analysis of it. First one starts as early as 5:45 a.m. and lasts until as late as 7 a.m. Then a second glare period returns later in the day, beginning as early as 4:30 p.m. and ends as late as 6:30 p.m. That's more than 3 hours per day when glare will be menacing our streets. 3 hours a day when it will be too hazardous to drive on the streets. 3 hours a day when it will be too hazardous to walk the streets. 3 hours a day when it will be too hazardous to leave from or return to our homes. Residents will be trapped in their homes during these periods, or worse, if away from home, they will be afraid to return to their homes due to the yellow glare roadway hazard. According to the applicant's glare study, the yellow glare on these 5 roadways will be present for 9 months of the year, beginning in February and lasting until October. Every day the sun is shining. Life in the neighborhood will be governed not by freedom of choice anymore, but by whether it's a sunny day and glare from the solar farm blocks our choice of activities. This is in direct conflict with Windsor Township Ordinance 8065B, determined that the proposed use will not substantially injure or detract from the use of neighboring property or from the character of the area, and that use of the property adjacent to the area is adequately safeguarded. This is also in direct conflict with Ordinance 8065G, impose such conditions in addition to those as required as are necessary to ensure compliance with the general purpose and intent of the zoning ordinance, which conditions shall include minimization of noxious, offensive, or hazardous elements. My analysis of the applicant's glare study was largely uncontested by the applicant and their expert witnesses. There was no challenge to the conclusions of my analysis that more than 10,600 feet of roadway will be impacted by yellow glare. This fact alone confirms the gross violation of Section N of Windsor Township Solar Ordinance prohibiting solar panels from casting glare onto adjacent roadways. There was no challenge to the conclusions of my analysis that the glare source will be 5 feet from the ground. This fact is what makes the yellow glare so dangerous. There was no challenge to the conclusions of my analysis that there will be 2 periods of yellow glare on the roadways lasting up to a total of more than 3 hours per day. The applicant has no concern for the safety of the roadway or the impact glare has on nearby properties. According to the glare study, yellow glare has the potential to cause flash blindness faster than one can blink their eyes. According to my exhibit, flash blindness is defined as having the same effect on vision as a flash from a camera flash bulb. Remember, the sun at its brightest is considered yellow glare. The applicant's glare study is completely inadequate when addressing nearby property owners' concerns about glare affecting the free use of their properties. As a reminder, Section N of the Windsor Township Solar Ordinance states that glare shall not be directed onto any adjacent property. The applicant's glare study comes up woefully short on this aspect of glare impact on nearby residents' properties. The applicant's glare study and expert witnesses only analyzed a handful of properties and testified that this is the representative impact of all remaining unanalyzed properties. However, only 2 of 14 properties analyzed by their study showed any yellow glare. Why? These 14 locations were chosen to hide the true impact of yellow glare on nearby properties. 6 of the 14 properties have no view of the solar farm. No solar panels will be visible from these locations since they are hidden from the solar farm by hills or other buildings. No need to wonder why the study found no glare of any kind at these locations. Coincidence? I think not. 2 more of the 14 properties located on Cluck Road reveal no yellow glare in the study, yet there is yellow glare projected to be on 1,000 feet of Cluck Road. The applicant's expert witness stated that these properties are located on either side of this 1,000 feet of the projected roadway yellow glare. What is the yellow glare impact to the 5 homes where yellow glare is predicted on the roadway a mere 100 feet from their front doors on Cluck Road? The applicant's witness testified that the points used in the study were representative of the glare expected in the area. Coincidence? I think not. These points were chosen to hide the true impact of yellow glare on Cluck Road. Another of the 14 properties analyzed is on the western end of Blau Road and shows no yellow glare in the study either. However, more than 90% of Blau Road, or 3,900 feet of roadway, is exposed to yellow glare a mere 100 feet from the front doors of the other 20 homes. The applicant's explanation is that this home is just outside the 90%. Incidentally, it is the only home of 21 on this stretch of Blau Road where yellow glare is not predicted on the roadway directly in front of the home. Coincidence? I think not. What is the glare impact on the other 20 homes located on Blau Road? We won't know until after the solar farm is built. Then it will be too late. Another 2 of the 14 properties are located on the north side of the project where it is impossible to reflect sunlight from panels facing south. Coincidence? I think not. Many objectors to this application have properties directly adjacent to the proposed solar farm. None of the objector properties were analyzed for yellow glare impacts to their properties, even though we were objectors from day 1 of this proceeding more than 10 months ago. Coincidence? I think not. The applicant doesn't care, or perhaps they analyzed these properties and found the yellow glare revealed did not support their case. It would have been easy to tell Mr. and Mrs. Job, for example, that we analyzed your property on Sunday Road and there is no glare impact to your property. That didn't happen. Coincidence? I think not. The applicant has offered some relief from the glare. When the 6-foot buffer plantings reach 40 feet, glare will be reduced. None of the applicant's witnesses or exhibits were able to predict when 6-foot trees will grow to 40 feet. In the meantime, we will be forced to endure the hazards and life-altering effects of yellow glare for many, many years, waiting for trees to grow. The applicant's witness has testified that yellow glare is pleasing and desirable like a pretty sunset. That was the ultimate insult by the applicant's witness. This statement shows the applicant doesn't care about the safety of Windsor Township residents or how it will impact all our lives. Simply, applicant doesn't care about the glare impact to us now. When they're trying to get our acceptance, does anyone expect we will get more compassion in the future when this 50-year nightmare becomes a reality and we start to experience how life-altering this glare will be? Vote no to prevent yellow glare from menacing our streets and our neighborhood. Vote no so we can safely use our streets at any time we desire and we aren't trapped in our homes or prevented from returning to our home at the time of our choosing. Vote no so we can be protected from the yellow glare impact on our properties that the applicant has failed to disclose. Thank you.
Thank you, Mr. Balthaser. Any questions from the board? Mrs. Balthaser.
I believe in silver linings and that people's actions and their consequences are connected. As such, I want to take this opportunity to actually thank the solar company for uniting our neighborhood. It has been my privilege to meet and work with so many respectful, genuine, and open-minded neighbors that have taken the time to understand different perspectives and find common ground. We are united in looking for ways to make our community a better place for everyone. And we understand that it's the small actions that add up to be big differences. Thanks again, Solar Company, for bringing us together. Supervisors, for many months, we have been presented with what I and others believe to be some deceitful and misrepresented documentation and testimony by Mountain Trail Solar, Leeward Energy, and their witnesses. We have heard one of their witnesses state that location, location, location is simply a line from a play and doesn't necessarily influence property values because they don't want us to think that our property values will negatively be impacted. But we all know that location is extremely important for real estate values. They have presented documentation stating that the solar panels create less glare than soil, that the glare we'll see will be like that reflecting off a pond and may be attractive sitting on the porch and not be something problematic that would prevent anybody from doing outdoor activities or traveling. Yet, if that were true, they would not have tried to submit new plans with more vegetative buffers or offered us $5,000 to plant trees on our properties so that we can block ourselves off from their glare. These actions contradict the presented data and testimony. They have testified that there will be no noise at night, yet other solar farms do have noise at night. So what magic do they have? They have said there will be no problems with runoff, yet they have modified the retention ponds. So if truly there were no problems, then these actions would not be necessary. By their own admission, the same engineering firm that designed the Lions Solar project also designed this one. And as documented in Fowler Exhibit number 7, there have been problems such as runoff and a contaminated well at the Lions project. So again, I ask, what magic will they be using here? With the exception of a few individuals, the residents of Windsor Township have nothing to gain, but much to lose if this solar farm becomes a reality. This project, if approved, will cause a lot of angst and danger to its residents, walkers, bicyclists, drivers, and passengers, including the children riding in school buses and vans. And any additional tax revenue that may occur will be far offset by the cost of mitigating future problems, such as mitigation of noise, glare, runoff, and others. As we have said before, solar farms are better suited for abandoned mine lands, and Pennsylvania has approximately 169,000 acres of them. There's also $245 million annually that has been allocated to Pennsylvania over the next 15 years to reclaim and treat these old mine lands and provide tax incentives for solar. So don't feel bad for the solar company if they don't get their project built here. They'll simply go somewhere else, more lucrative. And hopefully that will be to abandoned mine land that will actually help the environment and leave our precious farmland alone. If you believe that the solar company has no magic potion, you don't want to harm the health and well-being of residents, and you don't want to destroy Windsor Township farmland, then you must vote no. Thank you.
Thank you, Mrs. Balthaser. Any questions from the board? Ms. Fowler?
Apologize for my voice, my allergies are pretty bad right now. Since October, there's been a lot of hearings, testimony, and exhibits from the applicant and the objectors. The board has to determine, has the applicant met all of the appropriate ordinances for conditional use? The promise of future compliance is not enough. If the applicant did not meet all the ordinances, then it is your duty to deny this application. A larger project impacts more people. Based on the definitions in the NFPA 70, the General Electric Code, and an NFPA 850, a 64 megawatt electric power generation facility is a power plant. Any system that is over 2,500 kVA or greater is considered industrial. This project is proposed in the A Agriculture District. I'm not against solar energy. I'm against destroying productive farmland for solar energy while putting more than 40 families in harm's way. See Fowler Exhibit 1, where I used the Berks parcel tool and measured the size of this project from corner to corner. The longest corner, it was 1.72 miles. 1.72 miles, that's not a small amount of area. This is a big project. Some universities have put solar panels over their large parking lots. That's a win-win. Cars get shade, universities make make energy to offset their power bills. This project is a win for the applicant and the landowners, a huge loss for this township and the greater community. In Fowler Exhibit 2, I showed my investigation into Leeward Renewable Energy's solar portfolio. I found that their projects were built on fairly flat lands. They stripped the soil. There was evidence of sitting water or running water. Pile driving was really loud. Remember that I played those videos during my testimony. The photos used to show off these projects show the ground mostly bare. Remember, I calculated using the applicant's plans that every inch of rainfall we receive will have approximately 2 million gallons of water flowing off of 75 acres of impervious surfaces. This will affect anyone living downhill of this stormwater runoff. All of us are on well water. The applicant tries to discount real-world experiences. The applicant objected to my research because I don't have a college degree. To quote Dr. Andrew G. Huff, a PhD, MS, an epidemiologist who has extensive experience with the national security and national public health sectors, quote, "A person does not need to go to graduate school or college to learn a subject. You only need to be driven, curious, and passionate to become a subject matter expert," end quote. One can learn just about anything using the internet. I've spent over a year researching solar electric energy generating facilities, and the applicant has not refuted most of the evidence presented in the objecting parties' cases. The applicant has been sloppy or misleading through their expert testimonies and exhibits. The conditional use application lists the applicant as Mountain Trail Solar LLC. They are listed as an equitable owner, yet their attached zoning narrative and exhibit book included with Board Exhibit 1 shows the memorandum of option contracts with the landowners are with a Leeward Renewable Energy Development LLC. It states that Mr. Kaspari entered into his contract in March of 2021. Mr. Frederick entered into his contract in August of 2022. Included in Board Exhibit 1, there's a conditional use application fee check. It was written to a Windsor Township on 1480 Windsor Road, Red Lion, PA. That's approximately 70 miles away from here. During the hearings, the applicant's attorney requested to add a co-applicant, Leeward Renewable Energy Development LLC. See applicant's Exhibit 41. They submitted an incomplete option contract transfer. Leeward Renewable Energy Development signed and notarized it on December 1st, 2023, over a month after we started these conditional use hearings. Mountain Trail Solar LLC only filled out the first portion of the form. It did not get it notarized. If this is a legal document, and it's shocking that a company would change the option contracts in the middle of this proceeding, how can the landowners, residents, or the board trust the applicant if they're not an equitable owner like they stated in their initial conditional use application submitted on January 4th, 2023? The applicant has repeatedly been asked to explain the relationship between Mountain Trail Solar LLC and Leeward Renewable Energy LLC. We've been asked to know how is Leeward Renewable Energy Development LLC connected to Leeward Renewable Energy, LLC. The applicant did not provide a clear explanation. LLCs can go bankrupt. The applicant had experts testify in reports made for Leeward Renewable Energy, Leeward Renewable Energy LLC, and Mountain Trail Solar LLC, but not Leeward Renewable Energy Development LLC. So who's really behind this solar facility proposal? Who would be legally responsible if there's an issue? Is this another example of their sloppy work, or did they try to mislead the board? Leeward Renewable Energy has an active relationship with cadmium telluride solar panel manufacturer First Solar, who works with the U.S. Department of Energy National Renewable Energy Laboratory, also known as NREL. The NREL report, which is in Fowler Exhibits 5 and 6, should be used to determine a decommissioning quote, or estimate. The applicant's decommissioning estimate should be disregarded, as their expert witness admitted they have not decommissioned the project yet. If you haven't done it, how can you give us a quote? Someone who's never decommissioned shouldn't be trusted to decommission it with a bond. This bond protects the township, so you should ask for a large amount. The applicant has not demonstrated that building this project will not damage the public roads. A road bond should be a requirement if you decide to approve this project. It's not just the residents that use these roads. There are other people that use these roads to travel through the area. The applicant abused the conditional use hearing process. At the first hearing, the applicant presented new plans. They introduced new exhibits at the hearing. These exhibits were not given to pro se parties in advance. The applicant expected the objectors to be able to cross-examine expert witnesses the same night. One of the exhibits was over 100 pages long. Mr. Cluck complained about receiving these exhibits last minute. See transcript October 18, 2023, page 70. Quote, "My first comment is I'd like to reserve additional cross-examination when I've had an opportunity to review the hundreds of pages that were prepared and produced tonight. I was hoping, as a courtesy, I would have received the experts' reports. At the Planning Commission meeting, Mr. Gallagher and I had a discussion, and I specifically asked for the expert reports prior to the hearing. So I'm not able to adequately cross-examine, but I will start," end quote. How is someone supposed to be able to read through hundreds of pages and be able to cross-examine on the same night? It's crazy. The applicant has repeatedly demanded that all objector exhibits be given in advance to review, yet they didn't offer their exhibits in advance to all parties. Why? At the April 3rd hearing, I was expecting Mr. Sveen to be testifying, as I was given his CV and report in March, right before I was to present my case in chief. I thoroughly read and researched Mr. Sveen's report. I prepared my questions in advance, as I was going to be traveling to see the total solar eclipse with my dad. I gave my questions to another party member in case my internet did not work reliably on the road. I had internet issues that night. My Zoom wasn't working right. The applicant didn't bring Mr. Sveen that evening. He brought Mr. Tad Hardy, a new expert witness, to testify that night for their rebuttal case. Due to this bait and switch, I was not given adequate time to prepare or cross-examine Mr. Hardy, which led me to request to present a cert rebuttal case, which was partially granted by the board, for which I am thankful for. The applicant keeps changing the plans. The original plans submitted with their application were dated January 4, 2023. There was revisions on February 27, 2023. I've never seen those plans. On October 18, 2023, which is the first hearing, new plans not given in advance to anyone. On January 9, 2024, after all the objecting parties have presented their cases in chief, again, plans not given to parties in advance. New plans on April 29, 2024 were introduced on rebuttal. Part of these plans were submitted in advance, but not in completion. The applicant used the community's concerns at the Planning Commission meeting to revise their plans. The applicant appears to have used some of the objectors' concerns in their case in chiefs to revise their plans after they finished their case in chiefs. Objectors were not paid for pointing out the applicant's flaws in their application. They should not have been allowed to correct these flaws on the fly. If a resident submitted plans and then decided to modify the stormwater basins, the buffers, remove a bioretention facility for a substation, or add a maintenance building, I'm certain that resident would have been told, you have to reapply with your final plan. Essentially, the resident would be forced to start the process over. Why does it seem the applicant's being held to different standards? On one hand, the applicant claims to care about the community's concerns, and on the other hand, they say the community's concerns are not relevant. See transcript from October 18, 2023, page 36. Quote, "As you are aware, there has been a significant amount of community interest in this project. During the course of the Planning Commission review process, several residents expressed their concerns and opinions with respect to a number of issues. which among others includes stormwater management, property values, environmental impacts, and health and safety concerns. Mountain Trail is not dismissive of the concerns raised during the Planning Commission process. However, it must be noted that many of these concerns and opinions are not relevant to the determination of whether the application complies with the relevant standards. End quote. I highly disagree. The community's concerns are highly relevant according to Windsor Township zoning ordinance section 806 on conditional uses. I won't read these all to save on time, but I will mention the numbers. 806.5a, as in apple. This project is going to be more intensive than the definition for intensive agriculture, which in my opinion goes against the spirit and purpose and intent of the A Agriculture District. I have never seen a farm that's been developed turned back into a farm. Have you? Remember, no farms, no food. 806.5b, as in boy. This project will injure neighbors and the broader community. The stormwater basins will impact all of us as we rely on wells for drinking water and other uses. The erosion and sedimentation that can occur with large construction projects will be felt by all of us. This project is not flat, it has steep slopes. There are already water issues now. Imagine a field with over 100,000 solar panels. They're like little roofs. Noise. It's very quiet here in this community, especially along Blyle Road. When I did my noise measurements, it was averaging around 35 to 40 decibels. If this project is approved, the noise is going to definitely be changing, which is going to impact the character of this community. Blyle Road was not included in the applicant's sound study. Why was it left out? There's a lot of homes along Blyle Road. It's one of the most densest areas along this project. The Alliance Solar Project in Richmond Township is fairly flat. Despite meeting the township ordinances for that project, it's caused damages to the neighbors. The stormwater has destroyed the farmer's well, and despite having a new well dug, this farmer still does not have reliable, clear drinking water. 806.5c as in cat. The applicant has not demonstrated that they can build this proposed project while safeguarding the health and safety and welfare of the residents in the larger community. 806.5d as in dog mentions about fire protection. We have a volunteer fire department that's clearly understaffed. There's no fire hydrants around, water has to be trucked in if there's a fire. 806.5g as in Gwen. The board has the right to impose conditions if they decide to approve this project. Please consider protecting your residents from glare, offensive noise, fire risk, and stormwater issues. The applicant has admitted during testimony and exhibits that this project will cause yellow and green glare. That's a clear violation of the glare ordinance. The applicant has consistently misconstrued the glare ordinance. I'd like to mention that the original glare study, the author was not brought in to be cross-examined, which is a right guaranteed by the Municipal Planning Code. Mr. Hardy testified there's not much difference in PV inverters and that the noise from this project will be like the hum of my refrigerator. I measured the noise from the PV inverters at the Lion Solar Farm, and the average tonal noise was around 50 decibels after sunset on a Sunday evening. Windsor has a strict noise ordinance regarding sounds, especially tonal sounds. See applicant exhibit 11 about pile driving. They're thinking they're going to have at least 13,500 piles. Every single one of those piles is going to impact the ground, which could impact the water table, which could impact our drinking water. The applicant has not determined what panels they will use for this project or how many will be used for this project. When I dug into Leeward Renewable Energy's best practices by looking into their solar projects in their portfolio, many used First Solar's cadmium telluride panels, which contain cadmium, which is toxic if there's a fire. DC arcs and fire risks are real, despite the objectors' testimonies and exhibits show. We have no emergency response plan in writing. The applicant claims they will comply. That's not good enough. You've also claimed that the fire company will give you something towards a new apparatus for the fire company. That's also not good enough. There's nothing in writing, so I don't trust them. Experts testify that they'll let the panels burn out and consider that this area is remote, so it's not a problem to just let it burn. There are over 40 families that will be affected by this project. Let it burn is unacceptable. Smoke from fires can travel far and it can affect more people. This is a large project. Wetlands. This project has some wetlands. There are township ordinances that protect wetlands with specific setbacks. The applicant promised to not disturb the wetlands to the fish and wildlife when they added the Frederick parcels. Yet the applicant plans clearly show they're planning on running utility lines in the wetlands. How is this not disturbing the wetlands? The applicant got upset that I presented Leeward Renewable Energy's best practices and projects in their portfolio. I showed everyone how the sausage is made. The applicant thought prior projects were not relevant to this application. I strongly disagree. If I were to hire a plumber and I found out he doesn't fix leaking pipes, I probably wouldn't hire him. Mr. Hughes, the project manager and engineer of this project, also engineered the Lion Solar project, which has problems with flooding and erosion, drinking water, and impacted soils. See Fowler Exhibits 7 and 8. The detention basins are still not finished as of July of 2024. They're still working on them. The applicant has failed to demonstrate how they can build this project while protecting the health and safety of this community. I recommend that you deny this application, and I appreciate your time. Thank you.
Thank you, Ms. Fowler. Any questions from members of the board? Mr. Fowler.
I'd like to thank the board for letting me participate in this hearing. We've had a lot of stuff that's been talked about, thousands, I guess at this point, of pages of transcript, I guess. It kind of boils down to a fundamental question when I consider this whole thing. And that question is this: can you do what you want with your land? It's an important question, and it seems like that answer should be a simple one, but I draw an analogy to an iceberg. There's a small portion of the answer that's above the water. And I think that's the part that resonates with most Americans who cherish liberty and freedom. And that answer would be yes, it's my property. I paid for it. I pay taxes on it. So I should be able to do what I want with it. However, the larger portion of the answer is like the iceberg. It's under the waterline. It's extensive and it's complicated. And it includes what we call zoning. Now, inherently, zoning is a restriction of our First Amendment rights. It places limits on what individuals can do with their land. The Supreme Court ruled zoning constitutional in the 1926 case of Village of Euclid versus Ambler Realty Company. And ever since then, zoning has been pretty much universally adopted across the United States. Prior to zoning, if you had an issue with land use, you had to resort to applying what they called nuisance law. There's two types of nuisances out there. There's what are called private nuisances. They affect the use and enjoyment of private property. And then there's public nuisances. They interfere with the public health, safety, and general welfare. So if a landowner created a nuisance and private and public parties didn't like what happened, they could sue them. And this was an after the fact kind of situation. Somebody would do something and then there would be a lawsuit. Well, at that point, it's sort of too late. You may or may not be able to remedy the problem because it's an after the fact situation. So a century ago, zoning regulations came into being because it was thought that that was a way to solve this problem. If we prevent these things from happening in the first place, we don't have this problem of after-the-fact litigation. So really, what this comes down to is, does the applicant's right to develop the proposed project create private and public nuisances that will infringe on neighbors' use of their properties? I think the answer in this instance is yes. For example, glare. We've identified that as a nuisance. Mr. Balthaser has gone into the glare quite a bit tonight with his closing arguments, so I don't need to say very much more about that. But I do want to briefly talk about why is it that what appears to be an obvious issue of glare, the applicant interprets it and saying we're complying with this ordinance. How is that possible that we have such extremes of opinion on this? Well, I believe it's because the applicant used a creative interpretation of the plain language in the Windsor Township ordinance to argue compliance. The applicable portion of the ordinance reads, quote, avoids directed concentrated solar radiation or glare onto any adjacent property or public way, unquote. There are two parts to that relevant section, separated by a conjunction, the word or. The first part is the phrase concentrated solar radiation. The second part is simply the word glare. The applicant parses the sentence to read concentrated glare by attaching the adjective concentrated to the entire phrase solar radiation or glare. Then claiming a lack of definition for concentrated glare in the ordinance, they equate concentrated glare to red glare in their study. And because their study doesn't show any red glare, they conclude they comply with the ordinance. The problem is, there is a reason that concentrated glare is not defined in the ordinance. It's a fiction of the applicant. They just created it from plain text. Further evidence has been presented that the word concentrated glare is really not a common phrase. You can type that into the Google search engine and you can get to the very last letter and it still doesn't suggest the phrase concentrated glare. Noise is another nuisance. Ms. Fowler went into some details about noise tonight. I don't think I need to repeat it, but it's another example of a nuisance that we face with this project. Fire risk as well. Ms. Fowler also talked about that a little bit. I think we demonstrated, objectors demonstrated that DC arc faults can cause a fire within solar facilities. The objectors have demonstrated that solar panels can burn, and when they do, they burn dirty. And also have demonstrated that solar panels may contain cadmium in the form of cadmium telluride. The applicant's testimony has downplayed these concerns, but has not denied the fire risk or the presence of cadmium in solar panels. We were told by one of the witnesses for the applicant, Mr. Cleveland, that we live in a remote location. Well, we really don't. There's many residents that live right next to this project. So as Ms. Fowler had also stated, let it burn is not an acceptable fire plan. The applicant has not produced a fire plan as part of this application. So at this point, in concluding, it is unclear that the applicant will or can comply with all zoning ordinances, but it is certainly clear that the applicant will create private and public nuisances. If you decide to approve this project, either you have concluded that the nuisances are not substantial, or else the township ordinance have failed in their most fundamental purpose of minimizing land use conflicts for its residents. Therefore, I hope that you will agree that the nuisances are real and harmful and vote to deny this application. Thank you.
Thank you, Mr. Fowler. Any questions from the board? Okay, at this point we're going to take a 10-minute recess and then we will return with the applicant's closing.